ready?
Yes.
Yes, the whole thing. The whole thing.
Got our eyes? Mr. Pearson.
Seem to have made a mess of my gown. Before the short adjournment, I showed the court the letters before action,
Yes.
by which we say
Yes.
the consent to assignment was ratified. I showed the courts that both of the letters proceeds on the basis that there had been an assignment.
Yes.
And my submission is that it was known to all in the working group that assignment was the end of a process. And that process went through preliminary consent, then it went through formal internal checking, and then it went through the formal sign-off, which we saw by the 25th of November. Now, in referring to the assignment, submission is that the preliminary consent was implicitly adopted. Because the fact of there having been an assignment was contingent to the knowledge of the working group on there having been prior consent.
So this is implied ratification.
That's right.
An implied ratification must be unequivocal.
Correct, Michael.
And it must be such that the words could not be accounted for by any other interpretations.
Correct, Michael.
Now, it's your case on this appeal that there doesn't need to be prior consent. Is it not? Mr. Kershid's going to address us on that later. The assignments could be valid because consent was unreasonably withheld.
That's right, Michael.
So, referring to and even accepting the validity of the assignments does not necessarily import that you accept there's been consent. You could be accepting that consent was unreasonably withheld.
Well, I suppose that's just about true, Michael.
Well, that's the end of ratification.
But it does proceed on the basis that that is the basis upon which, that is the only alternative basis, the only alternative explanation for the reference to assignment.
But what has been referred to is assignment. And you say that must mean a valid assignment.
Yes.
And that's as far as it goes, as it were, in what was actually done.
Yes.
Now, what do we imply into that? Well, we imply that it was accepted, that the requirements of the contracts as to assignment were complied with.
Yes.
And that means either consent or consent was unreasonably withheld. And that's as far as we can go, isn't it? I mean, we know as a fact, on this stage of the argument, ratification, we know there was no actual consent. BNC did not consent. That's why we're arguing about ratification.
Well, that's the hypothesis.
Yes.
Yes.
So at that point, there are two ways that the assignment, there's only one way that the assignment could actually be valid. And that is by consent being unreasonably withheld. So prima facie, if BNC is accepting that the notices of assignment were invalid, the route to that is via unreasonable withholding of consent. So how can you imply that they accept that they consented?
Well,
they would know if they had withheld it.
I'm sorry.
Because they would know if they had withheld it, and one would be in a different marketplace.
I think that is right.
I don't know.
I mean, that's a very,
We're talking
very helpful
we're talking
intervention.
implication, not.
But so, as my lady said, they would know if they withheld it. So they plainly weren't proceeding on the basis that they had unreasonably withheld consent, because there had been no withholding at that stage.
Yeah, but you have to
It's your
look.
alternative case.
It is my alternative case, yes. But the
Could we write an alternative case? But therefore we're wrong in the judgment.
So if we are right on our alternative case, then yes, that's it, that potentially arises.
But maybe the answer then is that we have to assume for these purposes that you're wrong on the alternative case, because if you're right on the alternative case,
Then this doesn't.
this
arise.
is all academic anyway.
Exactly.
They're two different branches.
Yes.
But we're not looking at whether or not there was actually, whether consent was unreasonably withheld. We're looking at what you can infer from the fact that BNC spoke of the assignment as though it was a valid assignment.
Yes.
And what can one infer from that they are ratifying that they gave consent, or is it a possible inference that they accepted that that they withheld consent unreasonably?
In my submission, no. And the reason is this: at the time when these letters were being written, everybody was proceeding on the basis that there had been a valid consent. The point is made, and it's in. I've lost my bumpers now. Paragraph 348, I think, sub 6. Yes, on page 153 of the court bundle behind tab 8. No one seems to have raised the question of defects in the document, rendering the consent to the assignment invalid. So everyone was proceeding on the basis that a consent had been given. There was no question on the facts of them thinking that, well, we might have meant to consent, but we did so unreasonably.
But the problem is that we're not here looking at that this isn't a direct ratification of the consent. This is a ratification. So this is an adoption of, as it were, of the assignment.
Yes.
Of the validity of the assignment.
Yes.
The question is, what does one necessarily infer from that?
And the answer in my submission is one. Is that one must infer that they were accepting the validity of the consent given, because on the facts there was no question of consent being withheld. Consent wasn't withheld, whether on a good basis or on a bad basis. It was given. And the judge found that the working group looked at least at the 25th of November.
I think the trouble is nobody on either side was saying that there wasn't consent,
Yes.
and that so the question is when you or that the assignments weren't valid. The question is when you refer to the assignments, what are you deemed to be accepting by referring to the validity of the assignments? All you're accepting, isn't it, is that one way or another, within the terms and applicable rules, the assignments were valid. And that could be either because there was consent or because consent had been unreasonably withheld. And I'm not sure how you get out of accepting the assignment is valid, the fact that there was a valid consent when that wasn't a necessary element of the assignment being valid? I'm not sure it matters what they knew, because nobody was suggesting at that stage that they were invalid.
I think it comes back, my lord, to the submission that withholding or not is binary. Either it is withheld or it is not. And we know that on the facts, it was not withheld.
Yeah, but the point about the binary submission is that it supports the alternative case.
Yes.
On the hypothesis that the purported consent was ineffective. Because the argument then is, well, we asked for consent, it wasn't given, therefore it was withheld.
Yes. But the basis upon which it was withheld was something which was not known to anybody at the time.
I think the point I'm putting to you, I suppose, just to have another go, it's not a factual question. It's a question of what is to be inferred from adopting the validity of the assignment.
Yes.
And can you infer from the fact you adopted the assignment is valid that there had been consent? And what I'm asking you about is, if there is more than one way that you can get there, can you necessarily infer that there was consent?
Well, excuse me. What was being adopted at the time, my solution was the consent itself. Everybody was proceeding at that point on the basis that consent had been given. And
there's no reference in the letters to consent.
Well, there is reference in the first letter to consent. There's reference in the
initial letter before
action, sent by my clients, my lord.
Yes, but that's not referenced in the response. It just simply says the assigned debts, whatever the phrase is. Yeah. The basis upon which I proceed
is that in the minds of both sides at this point, a consent had been given.
Your mind isn't relevant at this point, is it, to ratification?
Fine. In the mind of BNC at this point, a consent had been given. And that's clear from, amongst other things, paragraph 348, sub 5. There had been a preliminary consent, and Mr. Hernandez knew that. Now, in my submission, in those circumstances, it cannot be that BNC were proceeding on the basis that they had withheld consent, and wrongly so. Their actions were consistent with their own belief.
Well, we know that can be the case because that's exactly what your case is in the alternative. That they may have thought they gave consent, but they in fact withheld it, and unreasonably so. I think that's exactly what Mr. Kershid is going to try and persuade us of later.
position is that the assignment is being confirmed. The assignment is dependent on consent. And what is being confirmed is that there's no need to have an argument about consent, because that is accepted.
What confirmed is no need to have an argument about consent.
Mr. Pearson, would you say the situation is the same or comparable with what's being considered in paragraph 346 of the judgment, or would you say not? There, the judge is saying it was common ground that the ratifying purported principal need not know the purported agents lacked authority, but they have to have full knowledge of the material circumstances. Is the situation that we're considering the same or different from that, in the sense that the material circumstances are that you've just said Mr. Fernandez knew that preliminary consent in the widest term had been given, and the fact that that might have a defect in it, which might lead to the legal argument about withholding unreasonably, etc., might be or not the same as a purported principal not needing to know about a flaw in authority. Is that a good analogy or a bad one?
I would submit that it's a good one, my lady. Your ladyship puts the point much better than I did.
I doubt that, but anyhow. Okay.
In my submission, the trial judge's conclusion in paragraph 350 is an evaluation of the evidence that I've shown to the court. For reasons that I've endeavoured to explain, it's not one that's plainly wrong, one that no reasonable judge could have reached, or rationally unsupportable. And I say this with real respect, because Deutsche Bank lays it down as a constraint on the overturning of evaluations of facts. It makes no difference whether this court considers with whatever degree of certainty that it would have reached a different conclusion. Now, it wasn't said by my learned friends, and rightly, that in reaching her conclusion the trial judge had no material advantage over this cause. The trial judge read the letters before action, having heard evidence as to how they came to be drawn up. The trial judge had also heard the evidence that justified her unchallenged conclusions in paragraph 348, sub 5, that Mr. Fernandez knew a preliminary consent had been given, knew that Mr. Lozano had purported to consent, and that others in the working group knew the nature of the response. The trial judge had also heard evidence, and it's in paragraphs 163 and 165 of the judgment, that the assignments had been, and that's on page 100, it's on page 108, that the assignments had been recorded in the records of BNC. The trial judge even heard from an 18-year-old trainee who gave evidence that the procedure leading up to the assignment was so well known that when Mr. Lozano made a supposed mistake of him, she called him out on it. And all of that, along with the language of the letter before action, in my submission, justified the conclusion that BNC adopted the transactions and thus ratified consent to the assignment of the agreements on its own behalf.
I would say the wording you just used there is the same wording the judge uses in paragraph 350.
Yes.
Adopted the transactions. And she says, and ratified the assignment.
Yes.
But forgive me for raising another topic, but that is simply wrong, isn't it?
That she ratified, that BNC ratified the assignment.
Well, they adopted the transactions. They didn't adopt the transactions, did they? They weren't the transactions, the assignments.
No.
Are not. BNC isn't party to the transactions and isn't party to the assignment. And so I think it shows that she was, at least in the way she expressed it, addressing the wrong question.
my lord, if I might venture to differ, if your lordship looks at paragraph 345 of the judgment, there is the quotation from Suncorp Insurance. Ratification may be express or implied, and will be implied whenever the conduct of the person in whose name a transaction has been entered into is such to show that he adopts the transaction in whole or in part. Mere acquiescence or inactivity may be sufficient.
Yes.
So what the judge was doing was fitting the first stage conclusions that she had reached into the legal test which the parties had agreed upon. That's the reason for that language.
Well, maybe. But she then says, and thus ratified the assignment.
Yes.
And that is wrong.
That is wrong. That is a slip. But as Mr. Dudikoff said, sometimes in the course of this case, people used assignment as shorthand. And that's what the trial judge seems to have done here.
Yes, thank you.
Transaction was adopted in the sense that the process of giving prior consent was adopted. That was the only role the BNC had to play in the transactions. Now, 2 points were taken orally by my learned friend yesterday. The first was that clear words would be needed to justify the conclusion that it was a ratification, because BNC was legally unrepresented when it drafted the letters before action. The straightforward answer to this in my submission is that the words were clear enough for the trial judge, and the court shouldn't go behind her finding for the reasons that I've already articulated. But it might be pointed out, as the court did, that BNC is hardly unsophisticated. It is a bank, a former state bank. It could have taken legal law advice had it wished to do so. The court may wish to look over to the other side of the room at this point. The letters before action plainly were drawn up with the benefit of some legal advice, because one of the participants to the working group was Mrs. Zabellia. I won't take the court to it, but paragraph 198, Roman 1a of the judgment records that she was at all material times BNC's legal director. And I'm not sure whether it's really here or there, but I might point out that there simply is no evidence one way or the other as to whether or not English law legal advice was sought. It would presumably be privileged. The second point taken is that the letters don't specifically mention the 13th of June email, and so they can't be taken to ratify that. And in my submission, that misses the point. What was being ratified was the transaction by which consent was given, of which the 13th of June email formed part. As I've already said twice, probably more by this point, there are unchallenged findings of fact that Mr. Fernandez knew a preliminary consent had been given, and others in the working group knew of the nature of that consent. And they included, of course, Ms. Marty, who had given it. And for those reasons, I submit that the court's conclusion that BNC engaged in ratificatory conduct should be permitted to stand. Now turn to the grounds of appeal. First of the sub-grounds is 2.1 of the grounds of appeal, which is on page 14 of the core bundle behind tab 2. It says as follows. First, the court was wrong to take account of and attach significance to the alleged role of the Central Bank of Cuba in preparation of BNC's responses to the letters before action. Now, like the first and second sub-grounds of appeal, this attacks the conclusion that the ratificatory conduct was done with full knowledge of the material circumstances in which the act was done. Specifically, it's an attack on paragraphs 348(1) to 3 of the judgment. I've taken the court through those already, and I've foreshadowed what I say is the short answer to this point. Even if the involvement of the Central Bank of Cuba is ignored, as BNC says that it should be, a reasonable judge could come to the conclusion, as the judge did, that the attendees were an extensive list of serious senior people, and one that speaks of a determination to deal with the letter carefully. The president of BNC itself was there, as were the incoming vice president, heads of the department responsible for consenting to the assignment of historic debt, and the legal advisor. And that's still in my submission, an extensive list of serious senior people. And that is, I would submit, enough to dismiss the subgrounds. If the court wishes to go further, it's necessary to look at the way in which the subground is fleshed out in paragraphs 23 to 25 of BNC's appeal skeleton, which is behind tab 3 of the core body, pages 25 to 26. And what the court will see from those paragraphs is that the trial judge isn't said to have been wrong in her conclusion. Instead, it's said that she should have ignored the evidence as to the role of the Central Bank of Cuba because CRF didn't plead that role or its significance. And the result, so it's said, is that BNC didn't have a chance to lead evidence on the point. And there are two responses to this, each of them I would submit sufficient to defeat the point. First response takes as its starting point the Commercial Court Guide, paragraph C 1.1 sub E.
I'm sorry, can I just ask for you to pause for a few moments? I think we need to rise.
I was just going to say.
Thank you. No, we don't need to rise, that's fine. I think that we probably dealt with enough of the detail on this point, so you can move on.
I'm grateful, my lady.
Sorry. So that was ground 2.1.
That was ground 2. Now cut out quite a lot. So, ground 2.2
Yes.
as follows. The court was wrong to conclude that BNC had reviewed the key document by which its unauthorised employees purported to give its consent to the purported assignments. And that conclusion is inconsistent with the witness evidence at trial and with the hearsay evidence on which the court relied to reach its conclusion, which in any event should have been given no or limited weight. And that is, I would submit, undisputably an attack on the trial judge's evaluation of the evidence. The BNC must accordingly convince this court the decision was one that no reasonable judge could have reached. And the court has already looked at the paragraph under attack, which is 348 sub 4 on page 153 of the core binder. The first thing for the court to note is that there's a good amount of evidence which points uncontroversially to the conclusion that the judge reached, namely that the 13th of June email was reviewed. As I have explained, there are uncontested findings of fact in the following paragraph that Mr. Fernandez was aware that a preliminary consent had been given as a foundation for the later documents, and that others of the working group would also have been aware of this point, and many of them, familiar with the BNC handbook, would know the nature of the response which had been given. Now, in this paragraph, the judge records that Mr. Fernandez accepted that it was an obvious first step to review the assignment documents, and that's not disputed. If I might ask the court to turn up supplemental bundle tab 25, page 104.
Yes.
This is part of the evidence of Mr. Valdea.
So the lawyer?
The lawyer, my lady, yes. The court will see that the trial judge heard live evidence as follows, starting from internal page 111. Line 22. I participated for some time in the working group, and there was a full analysis of everything that had happened. And that points, I submit, to the conclusion that the 13th of June email would in fact have been reviewed. Likewise, the judge's conclusion in the preceding paragraph, which I've dealt with, the extensive list of serious senior people, which speaks of a determination to deal with the letter carefully. Now, I submit that on the basis of that evidence alone, a reasonable judge could come to the conclusion that the 13th of June email was reviewed by the working group and Mr. Fernandez.
So are you saying that the judge found as a fact that the 13th of June email was reviewed?
Yes, my lord.
And where does she say that?
conclusion that follows, my lord, from the third sentence of paragraph 348.4. The hotly contested issue was whether this review extended beyond the underlying loan documentation and the letter of 25th November and into the wider assignment documents, including the letter of 13th of June. And it is that question that the judge was deciding when she preferred the evidence of Miss Marty in the hearsay proceedings, in the Cuban proceedings.
So you say that the basis for her saying that the 13th of June email was reviewed was Miss Marty's evidence.
It was in part Miss Marty's evidence, but it was additionally the evidence of Miss Zubeldia, which I have read out.
Miss Marty said nothing about the 13th of June letter.
No, that's
Anywhere
right.
Close to it.
She referred to getting the documents, and I'll come on to what that means. But just to be clear, the judge relied upon the evidence of Miss Marty. She relied upon the cast of characters and the determination to take things seriously. And she had in mind, I would submit, the fact that the working group knew that a preliminary consent had been given. Now, turning to the oral evidence given by BNC's witness, all of whom said, when asked specifically about the 13th of June email, that it wasn't reviewed. I've already read out the trial judge's negative assessment of that evidence, and it's well established that such an assessment of live evidence is quintessentially a matter for a trial judge. It would require something very clear indeed for the court to go behind it. And far from providing something clear, BNC has given this court no good reason for going behind the trial judge's assessment. The submission seems to be that because all of BNC's witnesses told the same story, the judge was almost obliged to believe them. If that is the submission, it's wrong. The trial judge's role was to assess the evidence and to form conclusions. She wasn't constrained to accept evidence that was not credible, studied, awkwardly given, and not speaking of frankness. Indeed, I would submit it would have been wrong for her to do so. And in light of the trial judge's assessment of the evidence, pointing away from the 13th of June email having been read, a reasonable judge could again have concluded that the email was in fact read. And turning now to the disputed evidence, the evidence of Miss Marty in the Cuban proceedings, as the trial judge recorded, Miss Marty said that Mr. Lozano sent me to ask for the originals of the deposit agreements from the Italian Banking Institute and Credit Lyonnais in Holland. He asked me for the documentation, and that we checked, everybody checked the documents. Three criticisms are made of the judge's reliance on that evidence. The first is that it was hearsay relied upon without a hearsay notice. It said in those circumstances that the judge should have given it either no or very limited weight, particularly because BNC's witnesses said to the contrary. I won't go back to the judge's assessment of the BNC witnesses' evidence. There are three answers to criticism. The first is that the amount of weight to give to hearsay evidence is a matter that's within the trial judge's discretion. There's no reason why she shouldn't have relied upon it simply because it was hearsay. She was entitled to give it weight, and she did. Second answer is that there was no meaningful opportunity to put in a hearsay notice in relation to this evidence. Now, here I need to go back in my notes a little bit. If I can ask the court to turn up that the submission is that the...
Well, it was accepted that a hearsay notice would have made no difference because she wasn't cooperating anyway.
Yeah, and one couldn't have been given, my lord, because the document that this all came out of was disclosed on the 12th of December 2022, a month before trial and long after hearsay notices had to go in.
Well, you can file a hearsay notice late.
Wouldn't have had much effect, but
none of this is all tinkering around the edges.
Yes.
The big question is what wasn't Miss Marty's evidence?
Yes. I will turn to that then. Now it's said that the judge's conclusion that the 13th of June email was reviewed is inconsistent with the transcript of the Cuban trial. What's said in the skeleton is that the hearsay evidence was to the effect that the only documents accessed by Miss Marty at the time were the originals of the deposit agreements from the Italian Banking Institute and Credit Lyonnais in Holland. He asked me for the documentation, is what she said. Now, if the court looks at the evidence, which is quoted in paragraph 348, sub 4, you will see that on its face it could be read in two ways. The words, he asked me for the documentation, could be read as simply reiterated, he asked me for the originals of the deposit agreements. Or it could be read as adding something, so the documentation asked for was in addition to the deposit agreements. However, we know that the latter must be right, since by trial it was common ground that the 25th of November letter was also read.
Sorry, I didn't hear that. You're saying at trial it was common ground that the November document was
Read. Yes, my dear.
But we don't know that was obtained by Miss Marty.
Well, we know that it was read in the working group. So if it's being said that Miss Marty's evidence means the only two documents available are the ones specifically mentioned in her evidence in Cuba, i.e. the assignment agreements themselves.
Can we go back? Can we go to the original document again?
Of course, behind tab. It's behind tab 34 of the supplemental bundle, page 156.
So in fact, the judge starts partway through that answer.
Yes.
The agreement, yes.
Raoul sent me to ask for the originals of the deposit agreements from the Italian Banking Institute and Credit Lyonnais in Holland. He asked me for the documentation.
So we don't know what the question was.
Not based on this extract. The full text was before the judge. And I'm afraid to say that I cannot remember what the question was.
But the words the agreement, yes, before the part quoted by the judge does seem to me to be relevant to understanding in context what the documentation referred to is. The agreement, yes. Raoul asked me for the originals. He asked me for the documentation. Yes. That does seem to be referring to the agreement.
Well, it may be referring only to the agreements. But in my submission, then you've got, he asked me for the documentation.
And the next question, do these two agreements refer, etc.?
Yes, so the questioner is referring to the agreements. But that doesn't tell you what the answer meant. We checked, everybody checked the documents.
Well, at line 10.
Yes.
The agreement, when you tell me the document,
Yes.
what are you referring to? To the original agreements? And then, did you see them? We reviewed them between Maria.
Those cannot have been the only documents which were fetched by Miss Zubeldia.
But that's what she's saying there.
Sorry, by Miss Marty.
She's asked there, isn't she? When you tell me when you say the documents, what
Yes.
are you referring to? To the original agreements.
I wonder whether I could ask the court to have a look, please, at page 93 of the core bundle. The quoted text, which runs for most of the page, is an extract from the BNC handbook, which the trial judge looked at extensively. The court will see that it says, if the legal letter... Sorry.
No, I'm lost. So,
I'm very sorry.
page 93.
Correct.
Yes.
And then, so there's some indented text.
Yes.
There's a large paragraph, ignore that. Two small paragraphs, ignore them. A bullet point, ignore that. It's the one that follows.
And then if the legal letter.
Correct.
Yes.
If the legal letter, telex or message, the acceptance in principle and signature control, with all other documentation requested, with the necessary requirements are already in the file, then the assignment is ready to be materialised. So the judge had seen evidence which indicated that there was a file which contained all of these documents. Miss Marty is being sent off to get the documents. And the judge, I would submit, was perfectly entitled to assume that when she gave her answer, what she meant was she got the file.
Well, I'm sorry, all the judge had, as we have, is Miss Marty's evidence. And that's what she has, that's what she seems to have preferred. So we have to go upon understanding what that is saying, accepting context. But are you really saying that reading through that section of evidence, from line 1 through to line 15, that the documents, that the documentation was not the agreement?
Well, I don't make that submission simply on the basis of the hearsay evidence, my lord. I make it on the basis of the wider evidence which was before the court, including the section of the BNC handbook, which I've just shown you, including Ms. Zubeldia's evidence, which I read out earlier.
What I understand you're saying is the judge found as a fact that Mr. Fernandez and others reviewed the 13th of June email.
Yes.
And the judge's basis for rejecting the evidence of all the witnesses who said, no, we did not review that document, was that she preferred this evidence here
That was not
as evidence to show that they did review the 13th of June email. Now, speaking only for my part, I don't understand that.
Well, my lord, that was not the only basis upon which the judge rejected that evidence. If your lordship could look at the second sentence of paragraph 348 sub 4.
As Mr. Fernandez accepted an obvious first step to take.
He accepted it was an obvious first step to take.
But that was to review the assignment documents. First sentence.
And that seems to be, was the common ground, as I understand it. Because it says the hotly contested issue was whether it extended beyond the loan documentation on the 25th of November into wider, including 13th of June. And that's the issue that she relies on Miss Marty for.
Well, she does rely on Miss Marty. But
And the question is, how does it help her?
well, I think the only submission that I need to make is that it was a conclusion which was open to her, that evidence meant that the broader file had been looked at.
Well, she doesn't say that. She just literally quotes, not fully, or I would suggest accurately, what was in the evidence. And she doesn't go on to quote the further important words. When you tell me the documents, what are you referring to? The original agreement.
But I go back to the submission that I made at the beginning. What the judge is doing here is drawing conclusions. She's not purporting to list all of the evidence that she heard and all of the evidence upon which she relied for those conclusions.
Well, she is saying, forgive me, she is saying that she prefers one bit of evidence to the denials of witnesses. And I think the appellants are entitled to say, look at what the evidence she preferred says, it's got nothing to do with it.
On one reading, my lord, it has nothing to do with it.
Well, I accept you've got to defend the position, but there has to be a degree of realism at some point, hasn't there?
But
I mean,
I would suggest, my lord, that my submission is perfectly realistic.
Okay.
We move now. There's a very brief point about the non-calling of Miss Marty, who could have been asked to explain what was said. I will simply say this: the judge was asked to draw an adverse inference from the non-calling of
why
Miss
didn't
Marty.
you call her?
Well, that is a good question, my lord, and I think the answer will probably be that that one of the defendants to this appeal, one of the defendants to the case was Cuba. She was located in Cuba and is a Cuban citizen.
But I thought it was fairly well established that there is no property in a witness.
That's right.
So you can't draw an adverse inference against another party for not calling somebody who isn't within their control.
Well, the submission would be that she is within the control of Cuba.
If you can control, and in fact it's her evidence, it's you who wants to rely upon her evidence.
Yes.
So the adverse inference should have been drawn against you.
We only received that evidence, my lord, 1 month before the trial.
Well,
I don't think we're getting much further forwards here. Miss Marty was not called
Yes.
by either party. So I think we should move on.
And the third ground, it's in the grounds of appeal. Court was, page 14, court was wrong to conclude that it was unnecessary in any event for DNC to have reviewed that key document in order, that's the 13th of June email, in order to ratify the purported assignments, in particular due to the centrality of full knowledge of the material circumstances in which the act was done. Now, as I've already said, this seeks to overturn the trial judge's implicit conclusion that in order to have full knowledge of the material circumstances in which the act was done, Mr. Lozano did not himself need to read the 13th of June email, by which prior consent was given. If that's correct, then it doesn't matter whether Mr. Lozano, in fact, did read the email himself. Turning the issue for this court is whether the evaluation made by the trial judge was one that no reasonable judge could have reached. The evaluation is the one or the implicit one, which I've just mentioned. In my submission, the decision under attack that it wasn't necessary for Mr. Fernandez to read the 13th of June email himself is one that was well open to a reasonable judge. If the court can turn back to paragraph 348.5, whether or not Mr. Fernandez looked at the 13th of June email itself, he was aware, unchallenged finding of fact, that a preliminary consent had been given as a foundation for the later documents. Put another way, he knew that a preliminary consent, such as the one actually contained in the 13th of June email, had been given. He knew, by another unchallenged finding of fact, that Mr. Lozano had purported to consent to an assignment by signing the letter and notice of assignment. He knew that a final consent had purportedly been given. Indeed, if the court looks forward to the following subparagraph, the court will see that it was common ground that Mr. Fernandez's working group actually looked at the letter which Mr. Lozano signed. So he read the final consent. And then, by a further unchallenged finding of fact, others in the working group would have been aware of this point, and many of them, familiar with the BNC handbook, would know the nature of the response which had been given as a precursor. Indeed, it's possible to go further. The judge found, in 348.3, that Miss Marty herself, the individual who wrote the 13th of June email, was at the working group. My submission on the back of this is a very straightforward one. Having made all of those unchallenged findings of fact, a reasonable judge could conclude that Mr. Fernandez had full knowledge of the material circumstances in which the consent to assignment was given, without himself poring over the 13th of June email. And for that reason, I would invite the court to reject the third subground of appeal. Moving on to the fourth subground of appeal, this is the one about pre-action protocols. The court was wrong to conclude that BNC's responses to the letter before action were capable of amounting to, and or that such response or responses did in fact amount to ratification. That's inconsistent with the practice direction, particularly in the circumstances of this case. It's also said further, it's wrong in principle to conclude that such pre-action correspondence is capable of ratifying the very transaction which is in dispute. Then there's another sentence which I've dealt with as far as I have time to. The outstanding part of the fourth subground breaks down into two parts. First is the reliance on the pre-action conduct practice direction. Secondly, there's the wrong in principle point. Dealing first with the pre-action conduct practice direction, BNC quotes selectively from paragraph 4 of it, set out in full in paragraph 31 of our appeal skeleton. And when it's set out in full, one sees that it says proportionality. A pre-action protocol or this practice direction must not be used by a party as a tactical device to secure an unfair advantage over another party. That's the section quoted by BNC. Then it goes on to say in the next sentence, only reasonable and proportionate steps should be taken by the parties to identify, narrow and resolve the legal, factual or expert issues. There are two things that I would invite the court to draw. First is that the paragraph isn't directed at preventing a party from obtaining any sort of action, any sort of advantage through pre-action conduct. It's directed at a particular kind of abuse, and I'm talking about the writing of excessively long and detailed pre-action correspondence with a view to intimidating the other side and driving up costs.
But nobody can suggest here that your clients were seeking to obtain a tactical advantage by getting BNC to ratify consent.
I
hopeless.
I quite agree with my lord.
I'm not really sure we need to.
In that case, my lord, I will say no more. Unless I can assist the court further, those are my submissions.
Thank you very much indeed, Mr. Pearson. Where do we move on to, Mr. Cockerill?
My lady, it is the respondent's notice ground 2,
Yes?
unreasonable withholding of consent.
Yes?
And I have about half an hour in which to address this ground by my calculations, because I think the appellants closed at about 1:30 and they get half of the extra 10 minutes this morning. So I've got till about 25 past on that clock by my calculations.
Okay.
So turning to the unreasonable withholding of consent on the assumption that contrary to the judge's findings and CRF submissions on this appeal, there had been some defect in the process which affected the validity of the prior consent that was given. So that's the hypothesis. In those circumstances, and as the relevant contractual provisions provide that the prior consent of the borrower should not be unreasonably withheld, 3 questions would arise. The first is whether, on the assumed basis we're proceeding, there was a withholding of consent, and the judge held, as a matter of construction of the English law debt agreements, that there was no withholding of consent. And it's that limited finding that is challenged by CRF by its respondent's notice. The second question, if there was a withholding, is whether it was unreasonable. And the judge held that had there been a withholding, it would have been unreasonable. And I'll come back to that and I'll develop that. I understand it's controversial. If there was an unreasonable withholding of consent, the third question is whether, because the provisos not unreasonably to withhold consent had not been satisfied, whether the conditions, that's the need to obtain BNC's prior consent, fell away, such that ICBC's rights to assign and its rights to transfer its obligations under the agreements became unconditional. And given her earlier conclusions, the judge did not decide this question. So those are the 3 questions I submit that we face.
Yeah,
Withhold.
just before you go on, I want to try and get one thing clear in my mind, just the relationship between the first and the second one. It doesn't seem to have been expressly stated anywhere that I've seen, although I may have forgotten it. But am I right in understanding that it was common ground at trial that in relation to this issue, reasons for withholding consent could be relied upon even if they'd not been articulated at the time?
That's right, they could, but
And
only...
So therefore it was an objective question whether reasonable grounds existed even if they'd not been articulated.
Yes, provided, and it's the proviso, provided they actually affected the mind of BNC at the time. And that's Lord Justice Slade in Bromley Park Gardens, who referred to the decision in Lovelock and Margot. So what Lord Justice Slade said, he found it surprising that in that case landlords, could refer to matters which hadn't been raised at the time, and he was prepared to assume that that was the legal position. Subject, he said, only to one proviso. It seems to me clear that insofar as landlords are allowed to rely on reasons which are not stated to the tenant, they can only be permitted to rely on those reasons which did actually influence their minds at the relevant date. So this is Bromley Park Garden Estates against Moss. It's in tab 15 of the authorities bundle, and I'm reading from page.
Well, the reason I ask the question is because it goes to this question as to whether it's on point one. It's a binary question, because one goes back to the example of the person who remains silent, and taking the learning from the landlord and tenant context that you're picking up there. So if the landlord has reasons present in its mind, it may not want to be seen to withhold consent, so it may remain silent. That's still a withholding of consent, and the landlord can come forward and say, well, nevertheless, these were the reasons I had in my mind, even though I was silent, and objectively they do justify my withholding.
Yes. Yes, that's right. So there would be a withholding if there was silence after a reasonable period. So you're expected to respond. If you stay quiet after a reasonable period, that amounts to a withholding of consent. And there is then a choice to be made by the tenant. The tenant can either play safe and apply for a declaration, or can play risky and assign anyway. Yeah. And assign anyway, and this is the point that Lord Justice Slade was making, the tenant has the right to assign anyway. With what he said, it is well settled that a tenant holding under a lease which contains a clause of this nature, the nature we're talking about, is released from such a fetter and has a right to proceed with an assignment of his lease if the landlord has unreasonably refused his consent. So it's a matter for the tenant. The tenant's got to look at the position and decide to play safe or play risky. If it plays safe, it applies to the court for a declaration. If it plays risky, it makes the assignment anyway, and then raises the unreasonable point in response to a challenge by the landlord. And the risk it takes is the landlord can raise points which weren't articulated, but only insofar as they did, in fact, have a bearing on the landlord's mind at the time.
Thank you, that's helpful.
If the withholding arises in the present circumstances, where in fact there was a purported consent, which turns out to be technically effective, there can be no factors which played upon the mind at the time.
Precisely. So
there couldn't be any. So it would be by definition unreasonable.
Absolutely correct. So my submission in relation to the second question on unreasonableness, in circumstances where BNC did not intend to withhold its consent but to give it, we say that the inadvertent withholding resulting from a failure by Mr. Lozano or Ms. Marty to take some formal step that was required of them would necessarily have been an unreasonable one. The prior consent which BNC intended to give should have been given, and that we say is a short answer to the question on reasonableness. But in any event, if we're dealing with unreasonableness, maybe I should finish this off. In any event, and I said it was controversial, but I come back to this, the judge made a finding that any withholding, she said there wasn't, but if there was a withholding, in reliance on what was pejoratively called the Vulture fund point, would have been unreasonable. Because as the judge found, CRF was not a Vulture fund. Now the point that was made by my learned friends is, well, the appropriate way forward is not to address hypothetical questions. And that's right, if there's no request for consent, there's no point going further to hypothesize as to what might have happened if you'd made that request. If you have made a request for consent and it's been withheld, it's right the judge should go further and analyse the position on unreasonableness in case she is wrong on withholding, and that's what she'd done. But in any event, ignoring that point, the judge did address the allegation about a vulture fund in the context of a dispute with respect to the reasonableness of withholding by BNC of its consent in 2020. So not 2019, but 2020, where the same ground was relied upon by BNC. And in that context, the ground was not a hypothetical one. And the judge made findings in relation to it. And specifically, those findings are at paragraph 365 to 371 of the judgment, which is page 157 of the bundle. And the paragraph that I'm going to end up with, in fact, is paragraph 371 on page 158. That's where I'm going to come to. Paragraph 371, 158 of the bundle. We say the judge found in the paragraphs leading up to that, paragraph 371, that CRF was a responsible investor in Cuban sovereign debt, which had for years made considerable and genuine efforts to engage with BNC and Cuba, with a view to renegotiating Cuba's sovereign debt for the benefit of both parties. But that at every stage, BNC and Cuba ignored CRF's overtures and declined to come to the negotiating table. Faced with 6 years of silence, CRF decided to adopt an alternative strategy in the hope that it would persuade BNC and Cuba to engage. CRF sought to have a small fraction of the portfolio of Cuban sovereign debt that was being held by ICBC on its behalf assigned to it in its own name, with the view to being in a position to threaten litigation. But even then, as CRF letters before action made clear, the hope was that it would be possible to resolve matters amicably. But regrettably, BNC and Cuba declined to engage, either then or since the litigation was commenced. And in the result, therefore, the judge concluded at paragraph 371 on page 158 that the withholding of consent on the basis of CRF's vulture fund nature or supposed irresponsibility as a creditor is one which is unreasonable in the sense that no reasonable person would have regarded either of these on the facts reasonably available as a reasonable basis to withhold consent. So she makes the finding. And that is why, when one moves forward to paragraph 377, Roman 1 in the bundle, the judge's conclusion with respect to the 2019 request for consent was that had there been she found there was no withholding, but had there been a withholding on the basis of CRF's nature or approach, it would not have been reasonable. So the question of reasonableness has been decided, or unreasonableness has been decided, we say. But in any event, there was no evidence before the court below that Mr. Lozano or Ms. Marty considered CRF to be a vulture fund at the time in 2019. And this takes us to the Bromley Park Gardens point. They did not have this in their minds. It did not influence them. What is relevant, we say, is the actual state of mind at the relevant time of the party from whom consent was being sought. What needs to be considered are the factors which actually influenced him. In this case, however, there was no evidence that Mr. Lozano or Ms. Marty were actually influenced by any consideration of whether CRF was a vulture fund. Had they been so influenced by any such factor, they would have refused consent rather than given it, or on the present hypothesis, sought to give it. Now, my learned friend refers to the decision of Mr. Justice Eder and Falconera Shipping, where Mr. Justice Eder held that reasonableness of a shipowner's withholding of approval was not to be tested by reference to a matter which came to light after the date of withholding, namely the evidence of mooring experts produced as part of the preparations made by the parties for trial. And what Mr. Justice Eder said at paragraph 108 of his judgment is that this evidence, the later evidence that came to light, is in reality irrelevant, because in deciding whether the owner's withholding of approval was unreasonable, the question of reasonableness must, in my judgment, be viewed at the time when the withholding took place, on the basis of the evidence reasonably available to Captain Papapostolou and the owners at such time. Now, that's a perfectly understandable decision, but what it doesn't decide is that the relevant test is whether whether the information was available at the relevant time is the information by which you judge reasonableness. You've got to have regard to the evidence which actually influenced the minds of the relevant person. And that's what Lord Justice Slade said, citing the decision of Lovelock and Margot. So in relation to unreasonableness, we say it is unreasonable. That's obvious because they tried to give consent, they didn't. The judge found it was unreasonable, and in any event, there was nothing in the minds of the relevant people to say that they had any such idea about Vulture Fund or anything else. They tried to give consent. So that answers the second question. The first question, which was decided against CRF at first instance, was whether or not there had been a withholding. And we say, in relation to that first question, that on the true construction of the contractual provisions, which the judge set out at paragraph 10 of her judgment, they envisaged that prior consent will either be given or it would be withheld. Not refused, but withheld. If given, then ICBC will have satisfied the condition on its rights to assign, with the result that it could proceed to assign its rights and transfer its obligations. If, by contrast, consent were refused or otherwise withheld, for example, if BNC did not respond at all or sent a non-committal response, which neither amounted to the giving of consent nor an express refusal, then ICBC could assess whether that withholding was unreasonable and thus decide whether to proceed with the transaction regardless or to abandon it altogether. The contractual provisions do not envisage ICBC being left in limbo, not knowing or not being able to assess whether it can assign or not. And a similar question of construction arose in the Barbados Trust against Bank of Zambia case, which is in the authorities bundle at tab 9, page 127. And I'll come to just a paragraph in that judgment in a moment. But it starts at page 127. But just to set the facts of that case, the question was whether a debt due from the Bank of Zambia had been validly assigned in circumstances where Clause 12 of the relevant facility allowed the lending banks to assign their rights and benefits with the prior written consent of the Bank of Zambia, such consent being deemed if no reply were received within 15 days of a request. So it's a different factual scenario, but that was the provision. The Bank of Zambia did not respond to a request for consent within 15 days and accepted that deemed consent had thus been given. But it contended that such deemed consent had been given only on the 17th of December 1999, the 15th day after the date of the request to assign. And as the assignment in issue had been effected prior to that date, on the 10th of December 1999, the Bank of Zambia contended, and Lord Justices Ricks and Hooper agreed that prior consent had not been given at the date when the assignment was effected. So that's the decision. In the course of giving his judgment at paragraph 59, and that is on page 146 of the authorities bundle, so this is authorities bundle, tab 9, page 146. Mm-hmm. And it's Lord Justice Ricks at paragraph 59, halfway through that paragraph at H, the line in line with H. There is a commercially sound reason for the requirement of prior consent. It polices the process. If the debtor has to consent in advance or is to be given a 15-day opportunity to consider his position, then the bank that wishes to assign has to give notice before it effects an assignment. And where a bank wishes to assign, that is before consent is either given or deemed in that case, there's no insuperable difficulty if its proposed assignment is made conditional upon prior consent being obtained or being deemed to have been obtained. So generally speaking, the consent will be there at the end of the 15 days. So the parties, in other words, would generally know by the end of the 15-day period that consent had been given, one way or another, and thus that an assignment had become effective.
Given or deemed to have been given.
Exactly, precisely, my lady. And then the important paragraph is paragraph 60. And Lord Justice Ricks went on to say, I say generally speaking because there are, in any event, problems of construction. And that is what he was concerned with, a question of construction. of the contractual provision, which may arise where the debtor answers the request within 15 days, but either without a positive written consent or with an express but unreasonable refusal. In such circumstances, when is the relevant provision proviso fulfilled? That question has not really been debated before us, but it can be seen that the contractual language presents a problem if there is an unreasonable refusal of consent within the 15-day period. In such a case, there is no actual consent, nor is there an apparently no reply for 15 days, which is the stated condition for deemed consent. A similar problem arises where the debtor replies within the 15 days, but without either giving or withholding consent. I would hazard the thought that both of these problems could be solved if no reply were stretched, as a matter of construction, to encompass no positive reply. On that basis, the unreasonable refusal, which is after all ineffective, and the merely holding reply, which after all is the equivalent of no reply in circumstances where the debtor expected to reply within 15 days or risk being deemed to have given his consent, could both be viewed as no reply.
Why isn't our case much simpler? I mean, this is a bit different because of the 15-day provision, which we don't have.
Exactly.
And as you've accepted, there must be a reasonable period for response to the request for consent. But after that, it's as simple as this. The word, as you pointed out, is withheld. It's
Yes.
not refused.
Yes.
And if a reasonable period from a request for consent has passed and there's no response, that's as much withholding as if they write back and say no.
Yes. That's exactly where I was heading.
And for my part, at least, this paragraph is dealing with a very different. It seems perfectly logical and sensible, but it's dealing with a completely different situation.
It is dealing with a different clause. I was going to draw parallels, but make the submission ultimately that my Lord Justice Arnold has made. So we say there was a withholding. We say it was unreasonable. And then the third question arises. And the third question concerns the consequences of an unreasonable withholding of consent. Did the conditions, that is the need to obtain BNC's prior consent, fall away in circumstances?
And you rely on Bromley Park, do you? You've already told us about that.
I do.
Or Justice Slade.
I do. It is in a number of cases. Mm-hmm. It is, but I do want to just lay the foundation because it responds to a criticism that's made of the reliance upon the landlord and tenant cases. So can I just make this point? I acknowledge, in this respect, that there is a difference between an assignment of rights and property and an assignment of rights under a contract. They start from different starting points. Whereas as a matter of common law, a tenant may legally assign his rights under a lease to whomsoever he pleases. Under a contract, rights are personal and not assignable, such that any right to assign has to be conferred under the contract itself. But whether a right to assign is conferred by common law in the case of proprietary rights or under contract in the case of contractual rights, it is the terms of the covenant in a lease and of the provisions in a contract which place the restrictions on the exercise of those rights. And the differences between property and contract do not affect the meaning of those restrictions. That is the point that Lord Justice Millett was making in Hendry and Chart Search, both at the outset of his judgment, when he said, whilst there are significant differences between the assignment of an interest in land and an assignment of the benefit of a contract, they do not bear on the question which arose in the case before him with respect to the meaning of the restriction placed on the exercise of a contractual of a right to assign. So he made the point there, but he also made it later on after having explained the difference between an assignment of a proprietary interest and an assignment under a contract, when he said, and this is page 77 of the bundle at E, these differences cannot affect the meaning of the proviso that consent should not be unreasonably withheld. Whether the subject matter of the proposed assignment is a term of years or the benefit of a commercial contract, the effect of the proviso is the same. So on the particular point which Lord Justice Millett was concerned, he concluded that the consent is not withheld if it is not asked for, and if it is not withheld, it cannot be unreasonably withheld. But that's not the only respect in which the decisions in the landlord and tenant context are relevant. They have a wider relevance as well with regard to the meaning of these provisos, common in landlord and tenant cases and common in commercial contracts. And then I move into what is the meaning of the proviso in the landlord and tenant context. And that is the point, my lady, where it is, there's a lot of law. Going back to Tree Law and Big in 1874. And it's again, Lord Justice Millett referred to it in Hendry and Chart Search on page 77 in the bundle. A covenant against assignment may be in absolute terms or conditional on obtaining the lessor's prior consent. And such a condition may be qualified by a proviso that the lessor's consent shall not be unreasonably withheld. Where the condition is qualified in this way, the lessor does not undertake not unreasonably to refuse his consent, but an unreasonable refusal of consent leaves the lessee at liberty to assign without it. So that's Lord Justice Millett in Chart Search, quoting Tree Law and Big from 1874. It's also made in Bates and Donaldson, Jason Property Developments, and Gab and Faroukzad, which my learned friend referred to. And in that case, Gab and Faroukzad, it was the deputy judge explained at paragraph 54 of the judgment that the tenant's covenant not to assign is in this lease in a form generally referred to as a qualified covenant. This means a covenant where the covenantor undertakes not to do something without the consent of the covenantee, and where that consent is not to be unreasonably withheld. Where a tenant covenants not to assign a lease and the covenant is fully qualified, the proviso qualifies the obligation. If the landlord does unreasonably withhold consent, the obligation ceases to bite and the tenant is therefore free to assign without consent and may seek a declaration to that effect. Now, Gab is a case where the tenant played safe and did apply for a declaration. But an alternative course is open to the tenants, as explained, is to play risky and assign anyway. And that was recognised back in Tree Law and Big, where Baron Amphlett stated that the lessee may assign if the lessor arbitrarily refuses his assent without any assent. So the lessee may assign without any assent, and the arbitrary refusal would be an answer to any proceedings which might be taken against him. 1874, and in Bromley Park Gardens, obviously that is a case where the lessee played risky, assigned anyway, on the basis that the landlord's refusal was unreasonable, was found by the Court of Appeal to be unreasonable, and therefore the order for possession was set aside. So that's a matter for the risk appetite of the tenant or the contracting party. So we say applying those principles to this case, therefore, even if there had been some defect which affected the validity of the prior consent given by Miss Martin, such that consent was thereby unreasonably withheld, the result would have been that ICBC could have assigned its rights and transferred its obligations under the agreements without any consent. And then it or CRF could either have sought a declaration that the assignment was valid, or they could have raised the unreasonable withholding in answer to any case advanced by BNC with respect to the validity of the assignment, as CRF has in fact done. And we submit that that is the presumed contractual intentions of the parties inherent in the assignment provision in Article 17C of the debt agreements. The agreement that BNC will not unreasonably withhold its consent carries with it an agreement that the need for consent should fall away if the consent is unreasonably withheld, such that ICBC's rights to assign became unconditional. And if ICBC assigned as it did, then the assignment is valid, the unreasonable withholding of consent being an answer to any complaint raised by BNC that its prior consent was not validly obtained. So we say that is the proper construction. And we say that on the present hypothesis that there was a withholding, it was unreasonable, The consequence was that the condition on ICBC's right to assign fell away, such that ICBC was free to assign without consent. That, we say, is the presumed contractual intentions of the parties reflected in the language of Article 17C. And if we're right about that, it is an answer to BNC's case. My lady, my lords, those are my submissions on unreasonable withholding. I just make two last points in the minute that's available to me. 2 points, perhaps going back to earlier. And the first is this. I wish to emphasise that the giving of prior consent to an assignment between a creditor and a third party, we say, is not a banking operation. To involve no change in BNC's position as regards its balance sheet, it is in fact a transaction in substance between an assignor and the assignee. And BNC's role in that is administrative only. It performs an administrative act, and that is carried out by as an administrative task. And the second, finally, if the court will indulge me, is as a point about the practical consequences. There is a need for a system which is practicable when it comes to giving consent to assignments. And a conclusion that prior consent needs 2 wet ink signatures is not a practicable one, and thus it is not the system provided for, we say, by the BNC signature rules. That is why the BNC handbook did not provide for it. So those are my submissions, if I may.
Thank you very much indeed. I'm not sure how this works. I think it might be Ms. McDonald.
My lady, Mr. Dudnikoff will go first, so
Fine.
we'll just swap round.
My lady, my lords, I will deal with ground 1 and at the end with respondent's notice point 1.
So ground 1.
Ground 1, Cuban law.
Yep.
The linchpin of much of my learned friend's argument this morning in response to ground 1 was paragraph 246 of the judgment. And if I may ask the court to turn to paragraph 246, I'm going to go through it in a little bit of detail again, I'm afraid, in a moment. But I'll first make the submission. I have 3 points to make in response. First, that the findings, such as they are that we see at paragraph 246, we say are to do with the form of the consent to assignment and not the authority of individual officials at the bank. And this, we say, is the correct way of interpreting paragraph 246, and indeed the only way of interpreting it consistently with the judge's findings on the B&C rules that we see later in the judgment at paragraphs 321 to 328. And contrary to my learned friend's submissions, we say those findings at 321 to 328 are not irrelevant, they're not alternative. They are a necessary part of the judge's decision and part of the ratio, and one has to make sense of them in light of 246, if at all possible. So how do we reconcile the two? The starting point in my submission is to appreciate where in the judgment 246 sits. The relevant issue that the judge is addressing in this part of the judgment is in the heading at paragraph, just above paragraph 222, prior consent. And as the judge observes at paragraph 222 itself, she says in the middle of the paragraph, it is useful to consider the main factual issue first. That is the question of whether, assuming capacity, authority, the acts relied upon by CRF constitute prior consent, it being common ground that under the agreements and guarantee, ICBC only had an English law right to assign with prior consent, such consent not to be unreasonably withheld. So that is the issue that the judge is addressing in this part of the judgment where we see 246. It is a factual issue determined according to English law principles. And we see the distinction drawn clearly, again, at paragraph 250, so just after and bookending, to use my learned friend's expression, bookending 246. So 250 says, this issue of prior consent is purely factual. It is the question which would be asked if everything took place according to English law. At the next stages, it is necessary to consider whether BNC had the capacity to give this consent for itself and for Cuba, and if so, whether Ms. Martin, Mr. Lozano's acts were authorized, which includes a consideration of whether consent as a matter of Cuban law required more than was given. So in my submission, what the judge is doing there, and it is clear also from the structure of the judgment, is distinguishing between, on the one hand, the question of whether the relevant act of the BNC official in question, Miss Marty here, amounted on its face to prior consent.
But if you're right about, and I understand the force of the point in terms of the architecture of the judgment, but in 246, she's expressly addressing a question about the relevance of two signatures and making the point that if consent comes at 13th of June, which of course we know is an email with no signature at all, then she must be intending at that point to be making a point about why two signatures is irrelevant.
Well, my lord, I'm going to have quite a lot to say about the contents of 246. But in response to that specific point, firstly, she refers to the handbook, and I'm going to look at that in some detail. She does not refer to the BNC rules. The handbook, it was common ground at trial, had no legal status, and that's the judge's finding. No legal status. The only instrument with legal status that's actually relevant are the BNC rules. And secondly, in light of the question as the judge articulates it at 222, and in light of the distinction which she then draws at 250, in my submission, 246, which sits in the middle, must be about the issue the judge is addressing. Prior consent, factual inquiry on English law principles.
All right, well, when she says this, if this is an argument which conflates two different issues, tell me what two different issues she's referring to.
Well, my lord, I can't assist on that. I cannot assist.
Because what's put against you is that the two different issues are very clear. One issue is, was there prior consent? And the other issue is a question of what you need to do when you get to the stage of signatures, which comes later.
Possibly. Another possible interpretation, however, given, as I say, the place where this paragraph sits, is that the judge is looking at the process that's prescribed in the BNC handbook as imposing a requirement of form on the consent. Not authority, but exactly, the form in which it appears. The point
she makes repeatedly is there's no requirement of formalities for prior consent, and I don't believe you to take issue with that.
No, that's quite right. In this sense, we accept that the point of what form should the consent come in was governed and accepted to have been governed by English law. And that's how it's decided. And as a matter of English law, there were no requirements of form identified that were relevant. However, and really, the point comes across very clearly from 250. It is not the end of the inquiry where the question arises as to whether the corporate entity that we have here, so the bank, is bound by what looks like and is found to be on English law principles.
Absolutely right. So you then go on to the question of, first of all, did BNC have authority corporately? That is answered in favour of CRF, you don't challenge that. And then, because that's not enough, you have to show that the individual had authority.
Yes, and that's how the judge approaches it. And in my submission at 246, she is not addressing, in some very shorthand, compendious fashion, points to which she turns in a greater detail later. And in fact, 246 comes in the judgment before we even touch on Cuban law issues, because we can see this just underneath 250. The heading is backdrop to the Cuban law issues. So the judge has not even started to identify, let alone answer the questions on Cuban law. So 246, in my respectful submission, cannot be about authority. And perhaps if we just turn to look at what is said there.
So you're going back to 246 now, because are you?
I am.
Lovely, because I'd just like you to walk me through precisely what you say it's doing.
Yes. So 246 says this: an argument was also deployed by reference to the supposed need for two signatures. However, this is an argument which conflates two different issues. If consent comes at the 13th of June, the evidence as to two signatures, the requirements for it, and to the extent relevant CRF's knowledge of it, pertains to a later stage. That is reflected in the process prescribed by the B&C handbook. Just pausing there. What is the evidence that the judge is referring to there? Now, we have looked at the evidence, the expert evidence on two signatures, and what that evidence pertains to is the act of consent. It doesn't matter where in the chronology it's given. It doesn't pertain to a later stage. It is concerned with the act of consent whenever it is given. Which makes sense because the B&C rules themselves do not distinguish between earlier and later stages of any process, and nor was Professor Mendoza's evidence confined to any later stage. He specifically addressed the authority of Ms. Marty, the sender of the 13th of June email, and he did so by reference to Articles 15 and 17 of the B&C rules. That's paragraph 94 of his second report. And when Ms. Rodriguez gave her answer in cross-examination, which we looked at in some detail, again, she did not qualify it by reference to any later stage. She was asked whether approval of an assignment would be a banking operation within Article 15L, and she said yes, a simple and unqualified yes. If the word evidence, in my submission, if the word evidence in paragraph 246 is to be interpreted, as my learned friend says, as referring to the expert evidence or the B&C rules, then I'm afraid that would reveal a fundamental misunderstanding on the part of the judge. And we say that that is not how, therefore, it should be interpreted. It is not referring to the evidence which is examined later in the judgment. That's my short submission or long submission on that. And that is why this is my second point. My first point is 246 shouldn't be interpreted the way CRF says. It should be interpreted in a way that does not introduce what we say is a stark and unexplained inconsistency in the judgment. So that's what we pray this in aid of. But going back to 246, so it refers to the process prescribed by the B&C handbook, which is important in my submission. Firstly, for the reason I have already given, which is that it was common ground that it had no force of law, and it lacks legal status. That finding we can find in terms of paragraph 336 of the judgment. So if paragraph 246 is to be interpreted as CRF contends, and to the extent that the judge's finding rests on the contents of the handbook, then we say that the judge's conclusion is based on an irrelevant consideration. The source of the two-signature requirement is the B&C rules, not the handbook. So that's my second point. My third point on this, it involves actually looking at some of the contents of the handbook that we see quoted in page 93 of the bundle. So in the judgment, there's a lengthy quote above paragraph 91. And we saw at least some of this, and my learned friend read out at least some of it, or most of it, earlier. It may have been yesterday. Now, the point, there are a couple of points I emphasize, but if we can just read from the top of the page. If there is a positive result in all the aforementioned checks, and then the brackets, after brackets, a tele email, SWIFT or fax is sent to the foreign party, informing him that it is accepted in principle, inverted commas, your request, and that you must send us a set of original and 2 copies of the official documents of the assignment, duly signed by the buyer and the seller.
Do I understand you accept that that's what happened in this case? There was an email accepting in principle.
There was, in substance. I can't remember the exact terms of the email, but that's what
I
happened.
think it says in terms in principle.
So, and the question that arises here is, why is it in inverted commas? And why in principle? And the answer to that is because nobody at the bank ever thought that an email, SWIFT, or fax asking for copies of documents and accepting in principle the request could amount to actual consent.
But that argument is known to you, is it? Because that would be an argument that the 13th June email was not prior consent.
Exactly, and that is not an argument I am running. This is quite an important distinction, my lord, because what I am trying to do is I'm trying to make sense of paragraph 246 and the judge's reference to the handbook. My submission is that it makes no sense to try and match up the handbook with the judge's findings on the 13th of June, because the handbook does not contemplate that the in principle acceptance of the request would be a consent binding on the bank. And that is why it does not prescribe 2 signatures at that point. And we see that again from the passage with the bullet point, which says the legal department, they review the documents and inform the foreign debt department by means of a letter if they're duly formalized in legal terms and if it is appropriate to proceed with the assignment according to the agreements clause and other details reflected in the documents. The if is very significant in my submission because it contemplates, the handbook contemplates that the bank is not bound by the in principle acceptance of the request.
Well, exactly. This would support an argument that what happened on the 13th of June was written water and that what mattered was what happened in November. But the judge rejected that and there's no appeal.
There's no appeal against that. That's absolutely correct. The point I'm making is a fairly narrow one, which is that if one looks at what the handbook says, it makes very little sense if one then tries to apply it to the judge's findings. Those findings, and in particular the finding on the 13th of June consent, that finding is made by the judge under English law as was common ground at trial. And what appears to be happening in 246 is the judge, having made that finding, then looks at the handbook and tries to marry the two up. And it makes no sense for that reason. The handbook doesn't fit. Square peg, round hole. It simply doesn't fit because it is contemplating, in my submission, fairly clearly that the bank is not bound as at the time the in principle acceptance goes out. That's what the handbook.
It doesn't matter.
It doesn't matter.
Handbook's not legally binding.
Exactly. Absolutely, and that's my primary point. So if what we say is the essential premise of the process in the handbook, the essential premise being that the in principle email is not consent binding on the bank. If that premise falls away, as it does in this case, because the judge found that the in principle email was consent, then the process that's described here, as I say, doesn't make sense and should not, time and effort should not be wasted on trying to marry it up with the judge's findings as a matter of English law. And this is relevant also to the point, my Lord Justice Phillips, the observation made yesterday that if, as the handbook says, the 2 signatures come late in the story, well, it's too late by then, at the point of materialization of the assignment. And we say, well, precisely because it would be too late on the judge's findings.
Well, she said it was too late.
Yes, of course it is, because she found that the consent was the 13th of June. But that is clearly not what was contemplated in the handbook.
The key answer to the 246 point, apart from obviously looking at the text of it yourself, is 250.
Yes.
And the fact that then goes on to the Cuban law issues,
Yes.
which have not even been addressed at that point.
Absolutely.
Notwithstanding that it's common ground that authority is a matter of Cuban law.
Yes, absolutely.
And also the fact that prior to that date she's not addressed your arguments as to why two signatures are required. So if she was to have found in 246
Yes.
that two signatures were not required, that would be fraud.
Yes. Precisely. So those are the points that I have to make on paragraph 246, which, as I say, was very much the linchpin of the argument presented against us. Moving on now to points of slightly lesser importance, but nonetheless deserving of some mention. The scope of the B&C rules. The submission made this morning was that the B&C rules did not apply to the bank's function as the body responsible for managing Cuban foreign sovereign debt. Because that function, it is said, I'm paraphrasing here, that function does not entail banking operations on the part of the bank. Could I please ask the court to look at paragraph 279 of the judgment, where the judge, in the context of addressing capacity, says this. That is the wording alone, but the same picture emerges if one iterates by reference to the legislative background. As the previous section demonstrates, the position of BNC has been gradually moving away from complete alignment with Cuba, but it has retained a particular position. In particular, as it moved away from being the principal state bank, its field of operations seems to have moved more towards management and administration. See paragraph 261 above. And the question that we ask is management and administration of what? And the answer is very clear. A very large portfolio of foreign debt. Hundreds of millions of US dollars worth of debt, and the management of that was BNC's principal function. To interpret the reference to banking operations as not applying to BNC's management of foreign debt would, in my submission, create a very large and unprincipled gap in the application of the BNC rules. What is the point of the rules if they don't apply at all to this core part of BNC's operations? And we can test it this way, that on CRF's case, Ms. Marty, in charge of the Foreign Debt Office, whose job was to manage foreign debt, was entirely unconstrained by the BNC rules. She stood outside those rules on their case because she was not carrying out any banking operations. And that's a very ambitious submission, we say, and it's wrong. So that's the scope of the
Well, even Bank of England, I suspect, would accept that it's carrying out banking operations.
Yes, of course. And there is, on this, there is a little bit of evidence to show the court, which has not surfaced yet, which goes to this point. It's Professor Mendoza's first report, which is not in the appeal bundles. Not in the appeal bundles. It was in the trial bundles, and it was adopted by Professor Mendoza in his second report, which is in the appeal bundles. I can either read out the relevant paragraphs, or I can hand up the whole report. Either is, or whatever the court prefers.
I think you should hand it up. Thank you.
Of course. So this is a report that was served more than 4 years ago, in 2020, at the start of this litigation, together with my client's jurisdiction challenge. And it was adopted by Professor Mendoza in his second report at paragraph 2. The relevant section is at page 5. We can see the question above paragraph 15, and the question is, in Cuban law, which individuals have authority to consent on behalf of BNC to an assignment of the rights and or obligations under the CL loan and the IBI loan? Please consider the position as of June 2019, November 2019, and now. And what Professor Mendoza does is he refers at paragraph 15 to the BNC rules.
As he says, it's about the use of signatures. What if consent can be given without a signature?
Well, my lord, that leads to the question.
On the judge's findings, that's what happened in this case.
Well, one has to distinguish what form does the consent have to be in. That's one question.
And as you've accepted, no formalities were required.
But the next question is the bank bound?
Absolutely.
And
That's
the answer,
a question of authority.
And the answer to the first question doesn't determine the answer to the second.
No, absolutely. I don't have any problem with that. But you can have authority to do an act which doesn't consist of signing.
Yes. If I could just show
yes, please,
the other paragraph. So paragraph 15, there's the reference to the rules.
Yeah.
16, there's a reference to section 17 of the rules. I'm not going to read all that. Then 17, and at 18, Professor Mendoza says only the president of BNC could sign a loan without a second signatory in June 2019, and then he identifies who the president was. The relevant Cuban law in relation to joint signatures is as follows, and then we have a reference to the legislation to sections 1, 4, 15, and 17 of the rules. And then Professor Mendoza says at paragraph 20, the provisions of the rules concerning joint signatures is consistent with international banking practices. There are an operational security requirement for transactions exceeding a specified amount. Such matters are part of BNC's usual operations at every level. This has been standard practice at the bank since 1999, during which time several resolutions have been passed by different presidents of the bank in relation to the double signature regime. The effect, this is paragraph 22, the effect of BNC's purported consent to the assignment being signed by only one person is that the assignment is ineffective. The double signature rule must be strictly complied with. It's an essential requirement of banking security for issuing consent and binding the bank in its operations, especially where international transactions are concerned. So Professor Mendoza's evidence is not at all surprising, I would submit, because banks all over the world impose strict controls on which employees are authorized to approve what in dealings with third parties. And we've seen that with ICBC. There were, as I mentioned yesterday, there were signature books explaining who was authorized to bind ICBC. Those were in the trial bundles, and it's not surprising. And it's also a very important requirement, which cannot be sidestepped in my submission by simply asking the question, well, was the process in the handbook followed? Which appears to be what the judge does at 246, at least on CRF's analysis of the findings. So, paragraph, and this is a very short point, paragraph 326 of the judgment, which my lady, my lord, have already looked at on more than one occasion, so I am not going to go through it again. I simply ask the court to note that Mr. Kershid this morning, when he was reading the paragraph, stopped in the middle after the words "such formalities," and in my submission it's very important to read on because the second part of the paragraph makes it plain that the formalities, and the only formalities that the judge is concerned with in this paragraph, it is the requirement which we said applied for BNC to get consent from the Ministry of Finance. That's the formality she's talking about in this paragraph. And that is why we see a reference to delay. Because a second signature would not create any delay, certainly not any material delay, whereas going to a government...
You have to explain that to me, because I don't get it. Because the paragraph starts by saying this approach seen both in practical as requiring a degree of formality and delay. And this approach must be referring back to what Professor Mendoza was talking about in the previous paragraph, which is 2AB signatures. He says nothing there about consent.
My lord,
What she says?
not quite. But paragraph 325 starts with Professor Mendoza's reasoning appeared to come back in part to his approach to capacity.
Right.
And this is very, very important, because Professor Mendoza's approach to capacity is dealt with in an earlier part of the judgment, at paragraph 273. In a different part, not to do with the authority of officials to sign documents on behalf of the bank, but the capacity of B&C, the power to approve assignments with or without the approval of governmental bodies, specifically the Ministry of Finance, MFB, and the Council of Ministers.
Well, to be sure, but maybe I've misunderstood, but that was all concerned with the issue of whether BNC had authority, not whether the individual had authority.
Precisely. No, that's exactly the point.
Your point is why if the judge is only dealing with two signatures, does she then go on to deal with getting consents? And the
Exactly. That's my point. And it does require a certain sense check when one is reading that to think, well, am I missing something? But no, this is what appears to have happened, is that the judge in 326, when referring to formalities and delay, is not talking at all about the two signature requirement. What is being discussed there is hinted at 325, which is Professor Mendoza's approach to capacity, and that is described a paragraph. Professor Mendoza's approach is described in paragraph 273 on an entirely separate issue of capacity to approve assignments by BNC, not the individuals. 273, and then the findings of the judge on that issue are at 296 and following, and 299.
It almost looks as though paragraph 326 you put in the wrong
is in the wrong place. Exactly. That's why I say it requires a sense check.
Anything to do at all with two signatures?
Absolutely. It's the reasoning, just on the face of it, that does not make sense.
Are you going to say anything about paragraph 335, which was relied upon again by Mr. Kershaw to say the judge had decided that two signatures were not necessary?
Well, my lord,
regardless.
Paragraph 335 is a very compressed paragraph. He uses the term validity, which is a difficult term to use when one is concerned on the one hand with the question of form of the consent, and on the other with whether the bank is bound, i.e. whether the officials had authority to act on behalf of the bank. So it's not entirely clear which point...
There was no issue on formalities, as you've accepted. The only question of validity was that of authority.
Well, my lord, the judge certainly appears to have perceived there to be an issue on formalities, because that's what 246 is about, we say.
But she makes the point elsewhere that there's no formalities. In fact, in more than one place. I mean, that's certainly one place. But I mean, she makes the point that there's no formalities required elsewhere. And as you've accepted, it was common ground.
My point about 335 is it follows a very, or I was about to say very lengthy, but certainly a substantial part of the judgment dealing with, again, with the handbook. With the handbook. We see that 332, 333, quoting from the handbook. And then 334 is analysing the process in the handbook. And our point is, and I made this point, is of no legal value whatsoever. One should be looking at the BNC rules. So the conclusion that we get at 335 flows from findings made on an instrument with no legal force and which was not relevant to the judge's task. So that's what we say about that. And finally, Article 54 of the BNC statutes. So this is CRF's Respondent's Notice Point 1. Now, it's a point that was not developed with any discernible enthusiasm by my learned friend, and the court was not shown any Cuban law evidence on the topic. And why is that? Because there was none. And why is that? Because Article 54 was not pleaded either by CRF or by us. And that's why my learned friend could not point to any evidence in his favour on it. It's nowhere to be found in the pleadings. But nor has my learned friend dealt with the, and I should say, the not pleaded point is a point that's in our supplemental skeleton, together with other points about Article 54. So it doesn't come as a surprise, but as I say, it hasn't been dealt with.
You're right implicitly to make the point that there's not a lot in the judgment about Article 54, except that one sees the CRF case summarised at 303, and one notices at 309 that Article 54 is one of the materials that is taken into account. That's
yes.
Little Roman 5.
Yes.
And then the evidence of Professor Mendoza in 311 and following does in fact reflect Article 54.
Yes, well...
And the findings are particularly relied on the ones at 313, and then the final conclusion in 319.
Yes, no, I absolutely accept. Article 54, it is, of course, referred to in the judgment. It was referred to in the, as I recall, in the written, both parties' written opening, and it was referred to in cross-examination. But there's no evidence has been adduced by CRF to support their case that the effect of Article 54 is to confer or enable the president of the bank to confer authority on individual officials at the bank to approve banking operations in their sole name or by their sole signature, even in circumstances where the BNC rules would otherwise apply and require two signatures. In other words, as I understand their case, Article 54 enables you to bypass the BNC rules. It creates a parallel regime. And that is not a point that was pleaded, and it was not a point on which any evidence was adduced by them. And in fact, I go slightly further than that, because I would say that the evidence that we adduced in cross-examination undermines their case, and it hasn't. We did refer to it in the supplemental skeleton, but my learned friend said nothing about it. It's the first supplemental bundle, tab 29, which is the cross-examination of Ms. Rodriguez on day 5, page 141 of the bundle.
Yes.
Page 141, internal transcript, page 64, where I asked the question, and this is not specifically by reference to Article 54, but I asked the question, would you agree that the clear effect of Article 17 is that the directors mentioned in Article 17 of the BNC rules cannot bind the bank to operations within the scope of the BNC rules with their sole signature?
Yeah, you took us to this.
Yes, exactly, yes. Yes, but it's as I say, it's not been dealt with, but it contradicts fundamentally their case on Article 54 from the mouth of their own expert. And the other, and I'm nearly at the end, the other point is that the case that's run on Article 54 by CRF is fundamentally inconsistent, we say, with the judge's findings, paragraphs 321 to 328 of the judgment. It's the paragraphs that CRF does not like and has made every effort to try and explain away, but that is because on a proper analysis, those paragraphs provide an answer both to CRF's case on Article 54 and on its case on paragraph 246 of the judgment. And as we say, they are relevant, binding, part of the ratio. That's all I had to say on Article 54. Safe to note that paragraphs 2 to paragraph 6 of the supplemental skeleton is worth looking or rereading at a convenient moment. It deals with those points. Those were all my submissions.
Thank you very much indeed. Which leaves the last few moments to Ms MacDonald.
Yes, I have cut my cloth down to pocket handkerchief size, so I will make in the time available to me some brief points on unreasonable withholding, ratification, and if time permits, which it may not, then notice. On unreasonable withholding, firstly, we addressed you yesterday on why we say the judge was right to find that the events of 2019 can't properly be described as a withholding of consent. And it may be useful to look again, the court has seen this recently in relation to Mr. Dudnikov's reply, but at paragraph 250 of the judgment, that's core bundle tab 8, page 129. And we see there, and the court has already considered the staged approach that the judge takes. So in other words, firstly, she looks at the question of, has there been, as a matter of English law, prior consent? And that, in her view, was the 13th of June email. So she says there, the issue of prior consent is purely factual. It's the question which would be asked if everything took place according to English law. So in other words, she makes a factual finding that as a matter of English law, prior consent has been given. And then she goes on, the next stage is to look at whether as a matter of Cuban law, and she explains what she's going to do then, necessary to consider whether BNC had the capacity to give this consent, and if so, whether the individuals were authorized to do as they did. Now, the relevance of this to the unreasonable withholding question, I would submit is this. She just found as a factual matter, as a finding of fact, that as a matter of English law, prior consent was given in the form of the 13th of June email. Now, in my submission, it's very difficult to reconcile that with the idea that simultaneously there was a withholding, again as a matter of English law, under the English law contracts, that factually prior consent as a matter of English law had been given, on the one hand, as she finds as a fact in 250, within the meaning of the English law contracts,
I don't understand the difficulty, because your case is that the person who gave the consent had no authority to give it. And we assume for this purpose that you're right about that. So Ms. Marty had no authority to give the purported consent. And therefore the answer to the request for consent was silence. Why is that not a withholding?
Well, my lord, in my submission, drawing attention to this finding, there's a finding of fact that as a matter of English law, consent was given. There's a subsequent finding that as a matter of Cuban law, the person who gave the consent didn't have the authority to give it.
But that means, but as a matter of English law, consent must not just be factual, but must be with authority.
Yes, but the submission that we make is that it's still impossible to look at the entire context that took place and to categorize this as a withholding. And we see the artificiality of this when we look at the next question, which was, well, if there is a withholding, was it reasonable? And the submission that's made was, well, it's impossible in this particular factual circumstance, it's impossible for it to have been reasonable because you have to look at what was in the minds of the person withholding the consent and then it said they didn't have anything in their minds about refusing or withholding or any negative
They
thoughts.
thought they were doing.
They didn't have any negative thoughts,
So
but they can now...
It equates to silence.
Well, it's saying in this circumstance that if there's a defective consent, to put it that way, in a non-technical way, it is ipso facto impossible. So if you were a truculent person or a difficult person, or you withhold for reasons that are actually in your mind, reasonably or otherwise, you have a chance later on, you end up in court, to seek to justify that. Say, I had these different reasons, you put them forward, you see if they're reasonable. In this situation, it said, well, it's going to be impossible. You don't have a chance to justify because you can't, it is said, point to things that would have been reasonably available to a hypothetical refuser at the time of the putative refusal. You have to point to your own mind, but then
And
the
your mind was
artifice
blank
is,
because you thought you were doing it.
but then your artifice is that your mind thought you were doing it. So in my submission, the artifice of the artifice and the unfairness, I say, of where you get to at stage 2, really points back to the question of whether it is conceptually necessary or appropriate to say that a defective consent, as we have here, must be equated to a withholding, and draconian and very odd consequences in terms of denying that party any attempt to justify, as is said, their actions.
Well, why should that be? The party in question was prepared to consent, but there were technical they had no reason to withhold their consent. They didn't identify any reason to withhold their consent. Is it right that years later the bank should find that its assignment was invalid when in fact there's no reason why that should be so?
I'm not sure I understand the question.
Well, I think you're putting to us with this submission is that it's a very odd position if you give factual consent and that's deemed to be an unreasonable withholding. I think what I'm putting to you is it isn't it actually the other way round? And it would be very bizarre if a bank finds years later that its assignment was invalid because although your client had no reason to identified no reasons to withhold consent, it is deemed to have consent is deemed not to have been given.
Neither given nor withheld.
Yes. I mean, what you're saying is that you have managed to succeed in putting it into limbo by sidewind.
Well, it's not a situation of limbo when one looks at the consequences of conclusion in a particular case that there was a withholding of consent.
You're saying you didn't consent and you didn't withhold. Isn't that limbo?
Well, it's not limbo. The totality of the bank's case is the assignments weren't valid. So it's not a limbo, it's fatal. So I'm saying the assignments weren't valid.
But that still left the request to give an assignment to which you hadn't responded either positively or negatively in your case. That is limbo, isn't it?
Well, in our submission,
maybe it doesn't make sense to argue about the term, but
there was a request for consent. The assignment was defective, it therefore didn't pass the title. That's not a limbo. That's a situation where title didn't pass.
Well, what's happened to the request then?
The request has been defectively, the consent has been given in a defective form. There's not some extant request out there remaining unanswered. So it's not a situation where no answer was given, such as the Gab case that we discussed yesterday.
So in effect, you're saying that in these circumstances, one doesn't go to withholding at all. One goes straight down the line, which says you need consent, you haven't got consent, there is no assignment, full stop, and you never go into the withholding
Yes.
territory. That's
We
what
say
you're
the
saying.
withholding analysis doesn't arise because it doesn't get past the first step. There wasn't a withholding. So there isn't a limbo. There was a request. It was acted upon. It was acted upon defectively. And there's not an absolute right by a party to cure it by this route. It will depend whether this route fits the factual circumstances of the given case. And we say in this case, the factual circumstances of the given case are as they are. In any event, it's overtaken by the 2019 request is overtaken by events because a request was made again in 2020, refused in the classic sense of the word. A letter was written saying no, and the judge found that that was a reasonable refusal. So 2019 has been entirely superseded by events. So one can ask again. CRF asked in 2019. They asked in 2020. The bank said no in 2020, and the judge found that to be entirely. So she found that there was a withholding.
Because of a change in circumstances, namely there was a criminal investigation.
Yes.
It's a big change in circumstances by 2020. That
was
was
a
the
criminal
basis for her saying it was not unreasonable.
Yes, exactly. She accepted an analogy that we drew with the circumstance where, for example, the Serious Fraud Office was investigating the assignment of some sovereign debt involving the United Kingdom, and it wouldn't, in her view, be unreasonable to, in those circumstances, decline to agree to the assignment. So there's not, in my submission, some 2019 request that's out there in limbo. To the extent that anything was in limbo, and we wouldn't accept that analysis, but it's been killed off in 2020.
And you also say, I think, that an attempt, albeit invalid, to consent in 2019 cannot then be recalibrated as an unreasonable withholding. That's what you say. You don't get into that territory.
Yes, you can't go back now and say there was an unreasonable withholding. And just for the court's note, because this is important and it's not something that I've been able to or will be able to address already, but it's important. Its discussion this afternoon has proceeded on the basis, and I want to make clear that this is not accepted by the bank and that we have detailed submissions to the contrary for the court's note, that the consequence of an unreasonable withholding is that the putative assignor can simply proceed to assign without the consent. Now, for the court's note, we deal with this in writing at paragraph 10 of our supplementary skeleton. We dealt with it in greater detail in our closing submissions at trial, and they're in the additional supplementary bundle at pages 116 to 118. And there we make the point that the landlord and tenant situation is not an appropriate analogy. That's not the position we say, and quite clearly on the authorities, that the unreasonable refusal in relation to contractual rights frees the requesting party simply to consign. There's an important discussion of the lack of any analogy between leasehold and contractual rights in the judgment of Lord Brown Wilkinson in Linden Gardens, which we analysed there. And of course, I would have wanted to deal with that properly in front of the court, but in light of the time, I will stop there. But there is not. We don't accept, for the reasons we set out there, that that the conclusion of an unreasonable consent is that ipso facto, the requesting party is just free to assign without the consent, and we set out our reasons there.
Thank you.
Thank you. Those are the points that I'm able to cover in the time available.
And what you were left to cover
was some brief points on ratification, and then I've never had the chance to address the notice point orally, but that's more than a couple of minutes, so.
Another 15 minutes. No. We'll stop now. Sorry about that, Ms. Whitmore. I think that in view of the time and in view of the very wide breadth of the submissions that we have received, we'll draw a line there. Thank you very much indeed.
I'm grateful.
Thank you to everybody for dealing so helpfully with this very complex case, which has been hugely interesting, which obviously should make everyone's hearts sink. And we obviously reserve our judgments. You'll be fully aware of how things are dealt with. Before I go on to that, I ought to also make clear that I'm also thanking all the people in the rows behind who no doubt have worked incredibly hard on this case, so thank you. You'll all be aware of how we deal with these matters in this court, that we circulate draft judgments and that they are circulated for the purposes of typographical errors and not for re-argument, thank you. And that they are also circulated only to those whose email addresses have already been given to the relevant clerks. If you need for any reason to extend your circle for consideration, then please don't just do it, please seek permission first. I just want to protect you from awkward situations. And as you'll also know very well, we hand down judgments nowadays electronically, and we also expect and hope that you'll be able to agree an order, and to the extent that you can't, please make short submissions and we will decide on the papers. Thank you very much indeed.
All right.